Peace to all the gods and goddesses. Back again with the vibes of the divine. I am the god Shango, and today, get ready to take another deep dive into this electrifying world of the Young Thug Rico trial. Let's get into it, family. What up, family? We had to go ahead and get into this. I had to bring a bonus for y'all, and we still doing the show tonight. We're going to start a little late at 7.
Are you handling this, or
so let's get it, family. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. Let's go.
This is 24 SC 004460 and 23 SC 188186. Both of these are State versus Kendrick. Hello, Mr. Kendrick.
Hey, how you doing?
I'm all right. How are you doing?
I can't find you.
I bet you could if you wanted to. I'm Judge McBurney, and we are going to work through bond in your two cases. You've got one case that's assigned to me, in which you're charged with aggravated battery, aggravated assault, and riot. You've got a whole bunch of co-defendants in that case. And you have an older case that is assigned to Judge Whitaker, in which you are charged with having an iPhone and AirPods while you were in the county jail. Ms. Bumpus represents you. Ms. Bumpus, are you representing Mr. Kendrick for bond only or through the duration of these two cases?
Through the duration, Your Honor.
Excellent. So Ms. Bumpus is here for the whole ride, and then Mr. Rao is representing the state. But like I said, all we're doing today is talking about bond. So I'm going to turn it over to Ms. Bumpus, hear from her about why you're a good candidate for bond in these two cases, and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll hear from me. So when you're ready.
Good morning, Your Honor.
Good morning.
And
Shout out to Caleb Bumpus. Yo, shout out to Brooklyn. Y'all get the slime umbrella started, starting to rain. I appreciate you, family. Let me do a quick roll call. Shout out to Wright Street, first one to hit the like. I see you. Appreciate you, family. The world's in. What up, what up? Tack Clouds in the building. What up, what up? I see you. Appreciate you, family. Jazine, I see you. Appreciate you. Brooklyn, what up, what up? Marilina, what's up? I see you, family. One Nation. Kimberly, Chloe Albert's Revenge, Fatima Barrett, what up, what up? I see you. Factual Lie, appreciate y'all being here. Just Lee, One Nation, okay, see y'all, appreciate y'all. Let's get back to it. Shout out to Caleb.
if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure it knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And
Bahira, what's good? I see you, family. Bahira Raesa Bay, appreciate you, family.
as we know, that is one of the factors in
Keisha
this
E.
court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity to be given a bond. This is a jail incident, Your Honor, and you know, I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're going to get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity.
Shout out to Carbon D. Appreciate you, family. I don't know, some people for some reason just don't like to hit the like button. Appreciate y'all being here though, family. Let's get it.
Be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom?
No, he was in trial, but the
The world's in. What's up? I see you. Appreciate you, family.
co-defendants were.
Oh, okay, so there was a prelim not as to him personally and directly because he was in 1C.
Yes, Judge.
But in 2B, one floor up, they went forward with some or most of the other defendants.
Yes, Judge. And in that case, it's my understanding that the judge decided that there was the facts did not arise to an aggravated assault, but a battery. And I know that, you know, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well. Because
Shout out to Keisha E. She said, I'm outside. Hey, y'all, I'm outside. What up, fam? I see you. Appreciate you stepping outside for us today.
because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high-profile cases.
And shouldn't a lot of that be the jail fault? Like, all this is happening on y'all territory, Rice Street territory. Like, he was found innocent of the charges, and then he got charges while he was in jail of the charges he was innocent of. That's y'all fault. What up, YP Com Chick? I see you, family. Appreciate you. Carbon D, I see you.
And there is a target on his back. And, you know, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the...
Yo, Chloe Albert's Revenge. If your audio is choppy, it might just be the YouTube, so try to refresh your browser and come back in. Appreciate you, family, because I'm checking on the side, and it's working fine on mine.
Resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are going to work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
No higher than $20,000. That's what's up. Hey, Kayla, you're a writer for that one. What up, Carla A? I see you. Appreciate you, family.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years, so it's not like...
April O'Neill's baby daddy. What's good, family? I see you.
There's a job at this firm where he was working for, hey, we held your spot for 2.5 years, but I trust you and he discuss something about the structure that would be in place, and that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper.
Yo, YP Comp chick, we got to get you a magnet. My bad. We got you coming.
But a real one. And as soon as he's released, I believe he's going to start back making music. And before this, and I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise
Miss D, what's good, family?
for Mr. Kendrick, while he's on bond for these two cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so, while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot. It's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation.
What's cracking, cousin? Joanna, we need your emoji too. What's your emoji?
To say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. So that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street. You'll be staying with this person. But those people need to not be people with whom he associated before. Not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety. You're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like. Who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them, and it's a great music making place, and the next day there's a dead guy in the parking lot. And that has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're going to be working on getting a studio in wherever he resides so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about what's that going to look like structurally, so that I know what I can put in the bond that's not sealed. Because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi? Okay.
He's
yeah,
a
it did work.
dirty,
It's
yo.
not on your end. It's something.
Even after all that was going on, he's still gonna fight against his bond. Like, what type of stuff is that? What up, Laugh Always? I see you. Appreciate you, family.
Happening in here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time. Okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation, and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you having been indicted on two separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who have also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wingley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder.
Yeah, I got the press conference coming up too. Appreciate you, family.
You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's, co-defendant Thomas's lawyers, is that not all.
For those who don't know, those who new around here, that's YSL Woody up at the top left. WOOTIE. That's YSL Woody. Mixed Chick, what up, family? I see you. Appreciate you.
And they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case. Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he
What up, Sashay Tucker? I see you, family. Appreciate you.
remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans.
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms. Hanson.
Yes, Your Honor.
All right. Somehow that device's volume got turned down. Look at that. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault case.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick. And essentially, there's a lot of commotion in the background because it's on a body camera footage. But they were able to secure a statement from Mr. Kendrick. And Mr.
Kendrick or from Mr. Wimber?
Both, but
okay.
With respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. I would disagree with the assertions that this is just a battery, and I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured...
Purple Paradox, what's good, family? I see you. Jack said he dancing for subs. Y'all got to sub up. Jack dancing for subs. That's Jack Glanville right there.
A conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then, on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by a convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116, and
Black Butterfly, what's good, family?
and it does appear that he is on
I see you. Appreciate you joining.
sentenced to a 15 years to serve 2 sentences, with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And
Yeah, right. How they gonna prove that? They just saying that he said that. The person that stabbed him is saying that, oh no, he was the aggressor, and then they gonna come and fight for it like they defending him. Welcome, Just Lee, to the Bronze family. Appreciate you joining, family. Y'all drop some slime brellas and keep the slime brellas going for the world's end. What up, Daniel Berry Sports Highlights? I see you, family. Keep the slime brellas going. We gonna do a live animation if we could get 5 super chats of $10 or better, or $9.99 or better. We'll do a live a live cover of how I do my cartoons. So appreciate y'all, family. Let's get it.
I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assault. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence.
I don't know how it went back to 1, so the setting was on 1, so we just need 4. We don't need the 5. We need the 4. Appreciate y'all, family.
That's where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, Ms. Bumpus needs to know what she and her client are up against, and I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got...
Drop the slime brellas for the world's end and keep the slime brellas going for Mixed Chick. Appreciate y'all, family. That's 2 of them. 3 more to go.
The two cases, the contraband and the assault, or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge,
What's good? I see you, family. Appreciate you, JT. And shout out to Keisha E. Keep the Slime Brothers going. That's 3. We just need 2 more, family. Appreciate the love.
there is one unindicted case that's been brought to our office, so I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we will be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick were to go to trial, could be 404B or could be linked to one of these other situations, or it would be something in aggravation at a bond hearing or at a sentencing hearing.
That's
Is
correct.
your best forecast with maybe one exception?
That's correct.
Okay. All right.
Thank you.
Thank you. Ms. Bumpus, I want to give you the last word. I'm going to not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. Certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that because the last time that my client committed a crime was in 2015, 10 years ago. And, well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not 2 separate crimes.
Okay.
This 2015 is the federal case.
All right. So there just was dual sovereigns, and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not 2 separate acts. And in me saying that, I don't know if this brings any or can help us get clarity on the warrant because my client's understanding is that the federal probation then trumped the state probation and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release, that's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation, hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these 2 cases. So as is par for Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimber. And you know that's how it flows. And so if that warrant is out there, then we need to work through that and setting a bond.
Keep the Slime Brothers rolling for Keisha E. Appreciate you, family.
Doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted, or it's dismissed, or I don't know, the judges tend to send.
That's crazy right there, right? He got a warrant because he was in jail. Like, what? And then nobody even knew about it? Like, what's going on? That's crazy.
Set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that that warrant's out of the way, and then it does make sense to think about what a bond would look like for Mr. Kendrick for the 2 cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those 2, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up?
And then they got to postpone the hearing because of that stuff. That's crazy. Or postpone letting them out or for the bond because of this. That's crazy.
There may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal.
Like because he got in a fight in jail, he's a danger to society. So let's keep him in jail. What?
3 months later, and then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff, and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. Like, all right, this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao's going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this.
What up, Ali? I see you. Appreciate you joining. And shout out to Chot Diggy in the chat. Y'all show Chot Diggy some love. Appreciate you, family.
Warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay? Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure. Good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case, don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured, so I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these 2 cases.
And Your Honor, how am I gonna? Can someone email me about the probation? Or?
I will keep everyone in the loop.
Okay, thank you, Judge.
All right, Mr. Rao, anything else from the state?
Yeah, Your Honor.
All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. We'll get it back when you leave.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you for being here.
Something that was something that I considered fighting, and obviously in consultation with my client, we had those discussions. But I think for the time being, it's my belief that that is what's best. Sometimes a change of scenery is important, and we're hopeful that a change of scenery and the continued support of so many people will lead to a happy ending to this story.
Do you know what state he plans to live in?
I'm not going to share that information.
Did the Alfred plea play a factor into accepting the plea in the negotiations? If that wasn't on the table, would you have been amenable to another plea where he still would have been free but not?
Well, the no contest to the gang act charges was important to us. We just sat through a trial for the last couple years where we've been bemoaning the fact that people have pled guilty to gang act charges when there was no indication that whatever was done was in furtherance of any gang. So I didn't want to turn around and do the same thing. So it was important that was accepted as a no contest plea. Certainly in a situation like this, and I thought ADA
What up, Tack Clouds? I see you. And yeah, we still going live tonight, family. 7 p.m. tonight. Well, it'll be 9 for y'all, 9 p.m. Eastern. I just had to get this in because, you know, it was too big, and I already got a whole show scheduled for tonight, which is going to be good. We're doing a breakdown of all the craziest stuff in the YSL timeline, so make sure y'all tap into that because it's about to be crazy. Appreciate y'all, family. Let's get it. The slime line, the YSL slime line.
Sperry said it well in court. Time was of the essence. There was really no reason for Shannon to continue to sit at 901 Rice Street to wait for the lawyers to figure it out. So we were appreciative of the state for agreeing to that resolution and that no contest plea.
We had to talk between courtrooms, obviously, to get there.
Right.
Ms. Bumpus, can you talk about the conclusion, well, not really the conclusion, but what the judge decided?
Y'all subscribe up to Queen Slime. Appreciate all y'all who came over here from Cat's channel. Appreciate the love, family.
Hi guys, how is everybody?
Shout out to Queen Slime.
Not decided.
KSPN.
Well, as you know, Judge McBurney made a decision to defer in making a decision based off of a potential probation warrant. I don't think the state knew about it or the judge knew about it, and I definitely did not know about it. So it was something that was a surprise to all of us and something that is still being confirmed.
Oh, so you didn't know going in there was a warrant, because you would have been obviously prepared for that.
Judge McBurney said from the bench that he was told from probation about the warrant. The state did not know about the warrant. Well, it's my understanding they did not, and the judge did not know about the warrant either.
So what is that like? What do you think next? Just got to sort that out.
Quickly going back to Mr. Jackson, how long has he been in jail now? Is it since the beginning of 2022?
Since March 17th of 2022, he's been in jail
And
continuously.
what's the total, I guess the amount of probation is?
So from the case that we just tried, we did not challenge the possession of a firearm from March 17th. So the jury found guilt on that one count. He was sentenced to 10 years to serve 3, commuted to the time he served. So
Becky Einhorn, what's good, family? I see you. Appreciate you.
he had 7 years of probation going into today already. The sentence is 15 to serve 3, commuted to time served, balance probated concurrent with that. So essentially, today he's gone from 7 years of probation to 12 years of probation.
So given all the cases, basically, it's 12 years of probation
Yes.
that he's now dealing with.
Correct.
That is how long to recruit you. 7 o'clock.
No, it's concurrent. Concurrent. 12 total.
On the other plea they took with Judge Whitaker,
He has 7 years probation, and now this is 12 years, but it's running concurrent. Yeah.
I know there's attorney-client privilege, but in general, are you able to just share? You were pretty reflective in there, talking about how he's grown up, he's learned a lot, he has 4 kids. Either one of you can talk about just kind of what his mindset is as what's this chapter.
The thing about Shannon that I love about Shannon is he cares deeply about people, and I think that this whole process, and probably certainly at the age he is now, where he's more reflective, he's realized how much certain people mean to him in his life.
Rainy Rain, what's good? I see you in the building, family. Appreciate you joining.
And it's just a matter of, we talk often, and I'm not going to share too much, but, we talk about life, and I think he's beginning to realize what's really important in life, and I've encouraged all those people also to make sure they continue to be there for him. And he just, sometimes I think we get so used to trying to survive on our own, and we forget that there's people there to support us. And sometimes we need to lean on those people. And that's what I'm hoping he will do, because I know there are many good people that are going to be there for him.
I see you, Ashley. What up, though?
Obviously, touched the grass.
So we've already been in contact with the sheriff department. The paperwork needs to go to the clerk of court. Then the clerk of court needs to fax it to 901 Rice Street, and they need to look it over. But I'm anticipating he would be released later on today. And if he's not, then when I wake up tomorrow, that's going to be first on my agenda, is to figure out what's going on.
Is anyone from his family wanting to talk or share their thoughts on his release now?
I don't think so. I think everyone's just appreciative, and but I don't think anyone wants to go public to make any statement.
Hey, what up? Cat Knot Williams in the building. Y'all show Cat Knot Williams some love. KSPN, Cat Slimes play nasty.
Hi guys, how is everybody? It's
At this time.
Mr. Kokomo, how are you feel today? Oh, very good.
No, I just hope that we can keep fighting and pressing for Mr. Kendrick so we can get him out sooner than later.
No one in the building. What's good, family? I see you.
I'm a halfway co-counsel.
She is.
Okay,
She's
I
being
just
modest.
wanted to make sure I wasn't, yeah.
She is co-counsel. Yes.
Does
Good.
he prefer, haven't been covering the whole thing. Does he prefer Mr. Jackson or Mr. Stillwell, or what should we?
So he prefers Jackson.
Okay.
He was listed as Stillwell in the indictment.
Right.
For the trial, and I just got so used to referring to him as Mr. Stillwell because I just thought it would be easier for the jurors to keep track of one name. But he does prefer Mr. Jackson.
Is it, because I guess we're
Attorney yet for Mr. McMullen, but we have the counsel for everybody else, so we'll just go ahead and get started with the final pleas for those people. Are there any guilty pleas that are going to be tendered today by any of the attorneys? Yeah, any of the defendants?
Yes, Your Honor. Anastasia Snedes on behalf of Mr. Miles Farley, and we have a plea of prison support.
All right, why don't y'all come on up to the podium, please? All right, Mr. Body, whenever you're ready.
Shout out to Becky. Appreciate you, family. Yo, why did Miles Farley, why he didn't want to take it to trial? I know it would have been a lot, like you got to pay and it's a lot of time, but he would have definitely beat that case. But he didn't want to take it to trial, though.
The gatekeeper.
For the record, this is
And everybody, I'm just going to give a reminder to just use the mics. They're in front of you and they're mobile, so you can move them up close so that everybody can hear.
This is indictment number 22 SC 183572, State of Georgia versus Mr. Miles Farley. Mr. Farley, if you'll please raise your right hand. You solemnly swear and affirm that the testimony about to give in the matters pending before this court will be the truth, the whole truth, nothing but the truth, sir?
Yes, sir.
Okay, you can put your hand down. Could you please state your true, correct, and legal name for the record? I'll let you sign before I ask any more questions. So two things at once.
And Mr. Body, maybe reposition the mic while he's doing that.
Yes, Judge. Ms. Farley, could you state your true, correct, and legal name for the record?
Farley.
And Mr. Farley, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here?
No.
And how old are you, sir? How
Diva,
far have
what
you
up,
gone to school?
family?
You sit. I got a bachelor's degree.
And are you able
Can you
to?
also speak into the mic, please?
26 and got a bachelor's degree.
And so are you able to read, write, and understand the English language?
Yes.
And do you understand you are charged in indictment number 22 SC 183-572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm in the commission
Shout out to Melarina. Appreciate you. Welcome to the family.
of felony. You understand you're currently charged or indicted with those counts?
Yes.
And do you understand that you have the right to plead either not guilty, guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial.
Yes.
And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir?
Yes.
And are you satisfied with the services that your attorney has provided?
Yes.
And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case?
No.
And Mr. Menendez, you waive formal reading of the indictment?
So waive.
So sorry to say, the motherfucking tired has been retired. I will no longer be playing that after some deep thought about that being Young Thug's daughter. And I know I wouldn't want nobody using my child as a joke for online, so I decided not to play it no more. We had fun with it, but appreciate y'all, family. That is retired.
Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to?
Yes.
And he advised that for count 1, RICO, the minimum is 5 years, the maximum is 20 years?
Yes.
And do you have any questions as it relates to that count, the single count that you'll be pleading guilty to?
No.
And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to...
Man, this boy went to school and all that, got a degree and all that, and y'all gonna try to put him on probation for nothing, for some crimes y'all didn't even find nobody guilty of, plus his clothing line? That's crazy.
The sentencing recommended for the count that you're pleading guilty to, but the court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum for the charge.
Yes.
Do you have any questions about that?
No.
Is he just pleading to count 1 and y'all are null processing the rest as a part of the agreement?
That's correct, Your Honor.
Okay.
Now, do you understand? Mr. Farley, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes.
And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else?
Yes.
Do you understand that you waive any and all defenses by entering a plea of guilty here today, sir?
Yes.
Do you also understand that by pleading guilty, you're giving up or waiving the following rights? The right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges proved against you beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. Do you understand by taking a guilty plea here today that you're waiving or giving up all of those rights?
Yes.
And Mr. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No.
Kayla is pretty, that's a fact.
And are you pleading guilty, sir,
What
because
up,
you have
abundance
decided
and clarity? I
in
see you.
speaking with
Abundance and clarity. I see you in the building. Appreciate you.
Your counsel, Mr. Menendez, that you believe that is in your best interest to do so?
Yes.
And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts that this plea of guilty places you in the same position as if you were convicted after a jury trial?
Yes.
Okay. And how do you plead to count one, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act in indictment number 22 SC
All right, Rainy Rain. Appreciate you.
183572?
Guilty on the Alford.
And Mr. Farley, is this Alford guilty plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to?
Yes.
And do you understand that you may have a limited right to appeal this guilty plea conviction?
Yes.
Do you also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, Your Honor.
Well, I want to make sure he
Yes, ma'am.
All right.
Do you also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw this guilty plea, which doesn't mean that the court necessarily would grant it or
That's a fact right there. Catnot Williams. If he get a 409 juror as a foreman, then it might be some problems. So, yeah, that trial is always risky.
not. It's just that's the time constraints that you have to file under those areas of the law.
Yes.
Okay. Do you have any questions about that?
No.
Okay.
All right, and your attorney, Mr. Menadas, will represent you until 30 days from now or the last day of this term of court, whichever is later.
Joni Ford, what's good, family?
And he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Yes, ma'am.
And just so the record's clear, I just provided to Ms. Persefield the indictment, which was signed by all parties as it relates to the defendant's guilty plea to count one conspiracy to commit RICO. Your Honor, had this case proceeded to trial, the state would have shown beyond a reasonable doubt that between January 24th
All right, Steph JK, Mama Duties first. Appreciate you, family.
of 2013 and May 8th of 2022, this defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise that YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL, doing so by protecting the power and territory of known YSL strongholder areas through acts of violence, also through other means such as social media, posting messages, images, and things of that nature. That's what the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association, Your Honor.
All right, I assume at least some of the evidence would have been the same as or similar to what was presented at the trial of some of the co-defendants that just was completed a couple of weeks ago.
Yes, Your Honor, very much.
All right, so I'll take that into consideration with regard to the factual basis as well. All right, anything else from the state?
Nothing further. The recommendation as it relates to, or the joint recommendation that the parties would make to the court, it's my understanding that the defendant obviously would like to tender his plea under North Carolina versus Alford, and I neglected to ask Mr. Farley, but it's also my understanding he qualifies for the first offender or treatment, and he is asking that the court treat him as a first offender, which the state has no objection to either, and the recommendation will be 5 years to be served on probation.
Ani H, what up, family?
All right, Mr. Farley, has your attorney discussed with you
Always lying love. Welcome, welcome. Appreciate you tapping in.
the First Offender Act and what all that means?
Yes, ma'am.
All right, and have you all discussed the potential upsides and downsides of that?
Yes, ma'am.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that you would not be a convicted felon. Understand?
Yes, ma'am.
All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alford. Do you understand that?
Yes, ma'am.
All right. Mr. Menendez, is there anything else that the defense would like to place on the record?
Yes, Judge. I just want to add a little bit of nuance to the plea in case the court's not as familiar, because a lot of it was on the front end. Mr. Farley is an HBCU graduate with no criminal record, and it's actually his marketing and his genius work as a businessman that even brought him into all of this, which is why we're asking the court to sentence us under Alford. In 2019, him and a friend created a clothing item, a hat, that was like a satirical play on the Trump hat where it said "Make America Slime Again" instead of "Make America Great Again."
No, but always lying love. I forgot to mention it, but did you see her face, Whitaker face, as they was reading them charges? She was like, really, with this bullshit? That's how her face looked to me, at least. I forgot to mention it, though, while it was playing. I was reading the comments.
And, Your Honor, the clothing brand never said anything about YSL. It was just using this youth term, slime, which I'm sure by now the court knows can have many different meanings in many different contexts. Mr. Farley is born and raised in the Cleveland Avenue area, and he does exemplify a lot of the great qualities of the people of that area, his creativity, intelligence, tenacity, his bravery in taking things this far, Your Honor, putting his foot down when he was faced with this, government abuse. But what he did next, Your Honor, is he went to Miles College and then...
Yeah, it's gone, but I will find something else to replace it, though. Appreciate y'all, family.
Despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he is a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Miles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again, and he's actually employed by a record label to be a handler for a musical artist. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business and his family. And so that's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alford. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant. He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home. It's better than jail, but I think we all know after COVID that that's not necessarily ideal. And he just doesn't want to go to trial. And that's why I think Alford is a textbook case for this type of situation. And so if the court has any questions, we would just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. But in tendering a guilty plea under Alford, Mr. Farley, you are admitting that while you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime. You understand that, right?
Yes.
All right. All right. I find there to be a factual basis for this plea. I will accept it under Alford, and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before,
I mean, I know that ain't that bad compared to what they be giving out over there, but 5 years probation, that's a long time to be staying out of trouble. He might want to leave Atlanta also.
how you perform during the next 5 years of this probation is going to determine whether you finish that. A person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you how you comport yourself and how you choose to behave going forward. What ultimately will happen at or before the end of that 5 years. Do you understand that?
Yes, ma'am.
All right. Are there any special conditions to this probation? Have y'all negotiated any?
The state didn't have any real special conditions, obviously.
What up, Real Talk with Retta? My bad. I didn't mean to pass you by. I appreciate you, family.
Then follow the law.
Okay. All right. Well, that is the sentence of the court. I need to ask if you have a weapons carry license. Do you have a license? Okay.
No, ma'am.
All right, that's fine. And while you cannot have any firearms during the course of your probation, if you successfully complete all your probation, you'd be able to possess firearms again. All right, Mr. Farley, good luck to you. I know that you have a very successful business, and let's just make sure that that business is on the up and up, and that you are following the law.
Mm-hmm.
All right, good luck to you. Thank you.
Thank you, Your Honor.
And is there somebody here from probation?
If he would wait, Miss Jolly is on the way.
All right. Mr. Menadas, wait until the probation officer, Ms. Jolly, can meet with y'all and get all of that taken care of.
Yes, Your Honor.
All right. Yeah, that'll be fine. And after you meet with her, then you are excused. Thank you. All right. Are there any other guilty pleas that are going to be tendered today?
Go sub up to Survivor Speak. Show her some love. Appreciate you, Chuck Diggy.
What I would like to do is, and we can just start up here with Mr. Mender, and I'd like the state to put on the record what the plea offer is. And I want everybody, all of the four defendants, and Mr. McMullen, we just heard from your attorney, and he believes he will be here by 11:30. He's apparently in Gwinnett County on some other case right now, and we'll have to just sort of wait until he gets here to handle yours. But this applies to you as well, for everybody. This is the final plea date. It's your first final plea.
Shout out to Chloe. She said she wants the Stacy Sibbett twerking emoji. Huh? We might can make that happen.
Before me, I know that y'all had a final plea before Judge Dempsey previously, but I gave you all the opportunity post the verdict in the case with some of the co-defendants to negotiate if you chose to, and have a final plea date, if you will. But this will be your last opportunity to enter a negotiated plea in this case, meaning you all in the state have agreed to a recommendation, and you can be assured that if I do not accept that recommendation, that you can withdraw your plea. Now, you can obviously at any point in time enter a non-negotiated guilty plea, and that would mean that you decide to plead guilty, and the state will make a recommendation as to sentence. Your attorneys will make a recommendation as to sentence, and it will be entirely up to the court to sentence. Could be above or below what any of the recommendations are. Could be exactly what one of the recommendations is, but as long.
Much love and respect to Cha Diggy. I hope you're the best with your situation. I hope everything works out as good as it can be. And y'all need to get up out that county too. They wildin'. What y'all doing out there?
As long as it is within what is permitted by the statutes. And then, of course, you have the right and opportunity to proceed to trial on the case as well. Does everybody understand that?
Yes, ma'am.
Okay. All right. So, Mr. Mender, you have this case pending, and you have another case pending as well. Is that right?
And Your Honor, so we were going to respectfully request to hold our announcement and to have an opportunity to approach the court at the bench whenever convenient.
YSL Nicole in the building. What up, YSL Nicole? I see you.
Before we move forward with the final.
All right. So I will come back to y'all. So, Mr. Garlington and Mr. Mondelli and Mr. Abadi, can you put the offer on the record for Mr. Garlington?
Yes, Your Honor. Your Honor, on December 9th of 2024, the offer was relayed to counsel for Mr. Garlington as it relates to the possibility of tendering a guilty plea. The recommendation from the state was
Drop some slime brellas in the chat for Ani H. Some slimes, some coins, and all that. Appreciate you, family. Drop a AH. Appreciate the super chat. What's that, from England? Appreciate you.
for the defendant to plead to count 1, conspiracy to commit RICO, count 49, which is the murder count, but it'd be reduced to the lesser included offense of voluntary manslaughter. And him to plead to count 50, which is participation in criminal street gang activity, and then count 54, possession of a firearm during the commission of a felony, with a global sentence of 30 all parolable time.
All right, and as a part of that plea offer, you all were going to null pros 40, 42, 43, and 51. Is that right?
That is correct, Judge.
All right.
So they null pressed all the charges, but only got him on RICO, which is crazy. From how? What did he do that was part of RICO? That's retarded.
All right, and Ms. Rondelli, you discussed with your client the potential sentences that could be faced if.
Hey, my bad. What's that? Britain? I don't know my flags. I went to school in Fulton County, so I don't know. No, I'm just playing. I don't know. I don't know these flags. I appreciate y'all though, family. I'll know it after today, I'm sure, because they gonna let me know all over the chat, clowning me.
He goes to trial and is convicted of all counts?
Yes, Judge, we've spoken extensively about potential risks of going to trial. I conveyed the offer to Mr. Darlington on December 10th, and we have had some discussion with Mr. Abadi since then. We are not in a position to accept the offer that's been placed on the record. We will be rejecting that offer. I will state that there are further discussions that are taking place. We understand the court's admonition, though, about
Yeah, and y'all can certainly present a joint recommendation. It's just not going to be negotiated per se at that point, in that you would have a right to withdraw the plea if the court didn't sentence in a court.
Hey, so that's Scarface, right? Am I wrong, or is that Scarface?
With that, but I mean, I will say, and this is certainly no guarantee, but I think across the however many years I've been on the bench now, I typically still, if there is a joint recommendation, certainly take that into account, and fairly often probably sentence in accord with that, but that is certainly not a.
Or is that the other little D? I don't know. Is that the other little D, or is that Scarface?
Guarantee. So, Mr. Abadi, would you be able to put on the record?
Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. It's still playing. That's they stream that froze, but we got it.
You understand that, Mr. Let me say another thing as well. I know that there was a not guilty or a not guilty verdict for most of the counts that faced the two defendants who proceeded all the way through to jury verdict. A trial for any of the four of you would be before a different jury. I would suspect that a lot of the evidence would be the same. The way it is presented might not be the same. The, I don't know, state's sort of story, theory, if you will, might or might not be the same. And the ultimate outcome.
There will be no love, I'm sure about that. Oh, shit, I pushed backwards. Appreciate y'all being here. There will definitely be no love, though.
You have once I get through, certain that those two videos would be presented again, and I'm already familiar with that, as are y'all, having had it in discovery for a long time now. But we're going to go ahead with the final plea now. So even though that motion is still pending, any plea that you might be interested in tendering at some further point in the case, if you ever decide to do that, would be non-negotiated. Just
understood, Your Honor.
Mr. Eppinger, you understand that as well? Okay. All right. So, Mr. Body, can you put on the record what the offer tendered to Mr. Eppinger was, please?
Yes, Your Honor. The state's offer as it relates to Mr. Eppinger was a global sentence of life imprisonment as it relates to the armed robbery and everything.
Nah, he gonna have the ankle monitor on for 5 years, I think. I have to double check, but I believe he gonna have it on, or probably for at least like 2 or 3 of those years.
Else to run concurrent on this indictment, but that sentence to run consecutive to the time he's currently serving in DOC custody, Your Honor.
All right.
Mr. Eppinger is facing a minimum of...
Y'all know Mr. Eppinger. We done covered him a couple times. Y'all know him. That's the wild. It don't make sense, but I don't know. I don't know. That's the one that wasn't tied down or chained down during his court hearings. He was the only one.
A life sentence and a maximum of 2 consecutive life sentences plus 145 years, Your Honor.
And I don't, this is just my quick count, but Mr. Eppinger is facing approximately 15 different felony charges on this indictment. Is that right?
That is correct, Your Honor.
All right. And if he were to proceed to trial and be convicted of all counts, in addition to everything running consecutively so that it would be, I'm sorry, I think you said 2 life sentences plus 100 and how many?
165 years.
165 years. That time could also be run consecutively to the time that Mr. Eppinger is already serving on whatever he's convicted of already. So have you explained that, Mr. Johnson, to Mr. Eppinger?
Yes, Your Honor.
You understand that, Mr.Eppinger? Okay. All right. And was there something else you wanted to say?
No, just based on the circumstances, I came to the podium
okay.
to make an announcement. But given the state's offer, Your Honor, at this time we would reject that offer based on our view and her.
What up, Amanda Robinson? I see you. Appreciate you. I'm not sure what flag that is, but appreciate you joining from wherever in the world you are.
Our view of the evidence in this particular case.
All right.
So, yes, we would reject that matter and like to proceed to trial.
All right. And once I get through everybody, or maybe everybody we can get through right now, I'll talk about trial dates. And I'll talk with y'all first about in the immunity hearing date as well. All right, thank you.
Your Honor, I believe that motion can be held as close to trial as possible.
Well, I mean, it could be, but I'm not interested in doing that. I'm interested in getting that taken care of as soon as possible.
Thank you, Your Honor.
All right. Not December, though. Not that soon. Okay. So, have we covered everybody other than Mr. Mender at this point? Yes. All right. So, let's talk about.
All right. Thanks, always. That's the other little D. Okay.
About then the number of witnesses, I would think maybe about 4 or so for the immunity motion.
Statement of no witnesses.
None? Okay.
Okay, so it's both Lil D and Scarface and Demiki and Garlington. Okay, it's all the same person. Got it now.
Your Honor, as far as witnesses in the case, I believe the only witness that may be necessary is the.
You can pick it up. It's not.
Is the complaining officer, Your Honor. That would probably be.
Okay. Well, there are 2 officers who got shot.
Well, actually, there's only one who got shot. There's another.
Well, one who got shot at and one who got shot. You're right. I stand corrected on that.
So
your motion is just with regard to the one who got shot?
No, Your Honor.
I didn't think so.
No, it is related to both, but the other witness is not necessarily important for the motion.
All right. So that should be able to be taken care of in what, 4 hours at most?
I would imagine no more than an hour.
I mean, I'd think 2, but half a day at most, right?
I don't even think it'll take that long, Your Honor.
Okay. All right. So let's go ahead and get that scheduled then.
I guess I would have my inquiry with the court and counsel would be it's the burden of the defendant to show that he's acting in self-defense. Typically, you don't call the complaining witness or the victim.
I don't know why they have so much problems talking on the mic. What's up, Jung Forever? I see you. Appreciate you, family.
To establish your intent and how you're acting in self-defense.
I mean, if he wants, whomever he wants to call, he can call. And I get that. So, do you think you'd be calling your client? Because it sounds like the state does not intend to call any witnesses.
Understood, Your Honor. It may be a situation where I may call my client after discussion with him, and it may be a situation where we may the calling of the witnesses is just necessary for the introduction of the video, and we can make arguments based on that.
Okay. So let's look at sometime the week of January 13th.
It's fine with the state. And it's just the video the state would stipulate to the video coming in, Your Honor, making a.
Okay. All right. Did you? I don't know if you heard that, Mr. Johnson. If it's just the video, then this.
Drop some more slime brellas for Ani H with the super chat. Appreciate you for all. Spread the love for this channel. Appreciate the love, family. Y'all show us some love and drop some slime brellas, some coins, and all that good stuff.
The state would stipulate to it coming in. I think there were.
January 13th.
All right. Let's do 10 a.m. January 13th.
Your Honor, I did file a response.
Yes, I saw that. Thank you. I appreciate that. All right. And then with regard to the trial, we're at this point looking at potentially 4 defendants for this trial. Does the state have, the last time I asked, we still were facing 11 defendants. So do y'all have a revised estimate as to the time it would take to present the state's case?
I think it would be less than 90 days, but in an abundance of caution, instead of over-promising, I would say at the most 90 days.
All right. And when you say 90 days, you mean from the time we start presenting evidence till the time the state rests would be 3 months' time, not 90 days of trial time, right? Okay. Just making sure. All right. And then obviously the defense would evaluate the state's case before determining whether they wish to present evidence. But any general idea what anybody thinks might get added on?
On behalf of Mr. Mender, if Mr. Mender was to go to trial, we would want one witness, and it would be, we would need a production.
Okay. Okay. Mr. Johnson, and I'm not holding you to it now, I'm just trying to get kind of an estimate.
Your Honor, based on our view of the evidence.
I need you to pick up that mic, I can't hear you.
Based on our view of the evidence, Your Honor, I do not believe that we'll have any witnesses for Mr. Evans.
Okay, and obviously that's assuming that it proceeds past the immunity motion. All right, and then I'll hear from Mr. Dark. But okay, so we're talking about probably still roughly 3 months. So 3 months is probably an overestimate on the state's case. Okay, so in terms of, thank you, I appreciate that. All right, and then with regard to the trial, we're at this point looking at potentially 4 defendants. What defendant said yes?
Days, but
all right. And when you say 90 days, you mean from the time we start presenting evidence till the time the state rests would be 3 months' time, not 90 days of trial time, right? Okay, just making sure. All right, and then obviously the defense would evaluate the state's case before determining whether they wish to present evidence. But any general idea what anybody thinks might get added on?
On behalf of Mr. Mender, if Mr. Mender was
Don't want redundancy. I'm not a fan. Well, redundancy every once in a while is a good idea, but I want to be efficient. Okay, so I'll pull and look at the last questionnaire, and if, y'all do the same, and if there are ones that you think we can strike, and any that you think we need to add, if y'all can just let me know that, and maybe we'll have, let's look and see what the 20th looks like. Maybe we can have, the 20th is the MLK holiday, so let's not do it that day. Let's do the 17th, which is the Friday before. Why don't we plan to just have like a status on, let's say 10 a.m. on the 17th of January, where we can, so if y'all would submit whatever kind of additions, deletions you would like to the jury questionnaire by close of business on the 16th. We'll meet on the 17th for a status. And
Judge, is that everyone in this courtroom on the 17th?
everyone who is still wanting to proceed to trial at that point in time. And in addition, Mr. Dark. And then I know the state had proposed, did y'all say February 24th as the beginning of trial?
Yes, Judge.
I had been thinking, I mean, is that a trial day for us? We can.
We could make it one, but not sure.
I'll speak in Mr. Dark's place. He had sent an email after I filed my motion. Apparently he may have leave filed on that day. I can't.
Let's find out whether he does. Because if it's not filed in this case, it doesn't.
things can be rescheduled, so that's not an issue.
All right.
Does the court expect to have jury filling out questionnaires prior to the day that we're starting?
I mean,
Because there's a couple things that can happen.
yeah.
So one is the questionnaire, and we
Stacy Sibbett in the building. What's good? Yeah, we still going live tonight. We're going to start a little late because I got to run a quick errand. But, yeah, we should start around 7, maybe 6:30. Appreciate y'all, family.
Mr. Abadi at the table, it might be more efficient, but the questionnaires give rise for strikes for cause outdate. So if we can agree to ones that are clear, then we can at least dwindle down and not have to waste time on whether or not
Well, they're clearly going to be stricken for cause.
right. And I think those things, like they can get the questionnaires done, we can.
Yeah, I mean, I definitely think we need to get the questionnaires back before we have them back for the, day of actual questioning, or days, I don't know, of actual questioning. So
Reading of the indictment is a day of us sitting there, or was a day, multiple days.
Let's see what we can.
I mean, it may be that the state's not intending to go forward with however many overt acts it was before, 213 or something.
Likely.
They may winnow down the indictment. Could you have that done before the 16th as well, or by close of business on the 16th? Okay. And I was going to say there's no reason to read the substantive counts that are against defendants other than these 4 or whomever it ends up being. But they may be overt acts anyway, but we wouldn't need to read the counts, even if they were included as overt acts. So, it would be a redacted indictment that we read.
Yes, sir.
But yeah, we'll talk in more detail on the 16th. On the 17th about that, about what date we're going to have jurors in, how many jurors we think we need to call, things like that. Okay. And then I know there are no, other than the immunity motion, no outstanding motion.
FFS is on the run. We're going to have to go get him. We're going to have to make sure we got him here at least by the night.
But are there going to be motions in limine, evidentiary kind of things that have not already been resolved? I need y'all to think about that and get all of those filed by January 16th as well. Okay. Actually, if y'all could get those filed by the 15th, that would be good, and then I could be taking the 16th to start looking at them, and maybe we could talk through some of them on the 17th.
Can we have a deadline for a discovery drop-off link?
I would sincerely hope that all the discovery has been shared by now.
I know they're working on consolidating some of the new stuff that came out as it relates to during the trial.
Okay.
But that shouldn't take very long. I know Mr. Dark has received the majority of, it's just taken a minute, it's over 8 terabytes to file for Mr. Dark. So that's been the focus. But I will make sure.
Yeah, so if you, the state, could put together your narrowed, cold, focused discovery.
It'll be, yes.
Can you get that? When do you think you could get that to all the defendants? Because even if they have everything, they'd probably rather have the smaller universe of things.
The first week of January, is that sure.
Yeah, that works. All right, so that would be, gotta find my calendar again. January 3rd. By close of business, January 3rd.
Oh yeah, and by the way, my bad. I'm saying 7 and 6:30. That's Pacific Standard Time. So for Eastern Time, it'll be about 9:30 or something like that. Maybe 8:30. I mean 8:30 or 9. Oh, and we hit the goal. Appreciate you, family. We will be scheduling a live animation editing video. Appreciate y'all, family. We hit the goal. We got all 5 of those $10 super chats. Shout out to Cha Diggy and Stacy Sibic coming in for the clutch. Appreciate y'all, family. Much love, much love. Y'all show them some love with the slime brellas. Let's see. Pull up Stacy Sibic first. Oh, and Cha Diggy back for another month. Appreciate you, family. Welcome back to the Copper Fam. Appreciate the love. And Stacy Sibic said, shout out to Flesh of the Gods. Flesh mods don't play. You F around here, you definitely will find the fuck out. Appreciate the love, family. Y'all show some love. Drop some slime brellas for Stacy Sibic.
All right, anything else we need to think about right now? All right, everybody else, I'm going to go ahead and release Mr. Abadi. Obviously, you'll need to stick around, and we had an anticipated 11:30 arrival time for Mr. Dark, so we'll hold on to Mr. McMullen as well, and then once we have Mr. Dark, we'll reconvene for his final plea and to discuss with him the deadlines we've set. Was there something else, Ms. Fagan? Oh, sure, yes, I'm sorry, you did mention that.
Appreciate the love, family. Y'all keep the slime brellas going. Show Cha Diggy some love. Show Stacy Sibbett some love, and all the donators. Appreciate y'all.
181814, indictment 22 SC 185532, indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, and you're going to be entering a plea of guilty to certain charges in these 3 indictments. So if you will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I need for you to tell me your name and spell it, please.
Shannon Jackson, SHANNON JACKSON.
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education?
Keep the slime brellas going for Cha Diggy. Appreciate the support, family. Love you FOGs in chat. Appreciate y'all, family. Y'all show us some love. Drop some Cha Diggy emojis or some slime brellas, some cold ones, some blue hearts, whatever you got. Appreciate you, family.
Education that you've gone.
Mine.
Can you read, write, understand the English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right. Now, do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of a felony, possession of a firearm by a convicted felon?
Yes, sir.
Do you understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement?
Yes, sir.
Do you understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years, which would have to run consecutive?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm by a convicted felon is up to 10 years in confinement?
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185532, in which you were charged in count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to...
Shout out to Sustain Overruled. Yerp. I see you, family. Still on the clock, but stop by. I see you. Appreciate you joining, families. Y'all show some love to Sustain Overruled.
Maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
Do you understand that for the entering auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And do you understand that for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement?
Yes, sir.
And do you understand that count 4, the failure to maintain insurance is a misdemeanor punishable by up to 12 months in confinement?
Yes, sir.
Now, as to case number 23 SC 188183, you were charged in counts 1 and 2 with participation in criminal street gang activity, count 3, possession of methamphetamine with intent to distribute, and counts 4 through 8 with possession of prohibited items by an inmate. Do you understand that for those counts 1 and 2, the gang activity, you could be sentenced up to 20 years in confinement?
Yes, sir.
Do you understand for the possession of methamphetamine with intent to distribute, you could be sentenced up to 30 years in confinement?
Yes, sir.
And do you understand the maximum possible punishment for each of those possession of prohibited items by an inmate is up to 5 years in confinement?
Yes, sir.
Now, do you understand that you have the right to plead either guilty or not guilty to any and all of these offenses? And if you pled not guilty, you would have the right to a jury trial in which the state would have to prove your guilt beyond a reasonable doubt.
Yes, sir.
Now, as your attorney, going over with you this form that I'm holding, the plea of guilty, acknowledgement, waiver of rights.
Yes, sir.
I remember. All right. And did you have an opportunity to review this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Sharp, are you waiving any potential defects in this indictment on behalf of your client as well as formal reading of the indictment?
So waived to both.
And Mr. Jackson, do you need any more time with Mr. Sharp? Are you prepared to move forward at this time?
No, sir.
Now, in relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea, that this also can be used in the future? It's what we call recidivist punishment, which means that if you got in trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand there could be what we call collateral consequences to this plea. What I mean by that is that this can have a negative impact on, say, your ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And do you understand this is a negotiated plea of guilty?
Yes,
which means that your attorney and I in the state have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes, sir.
Now, do you also understand that if you are under probation or parole, that this can have a negative impact on your probation or parole status? And to be clear, this would not have a negative impact on the offense for which you just were sentenced, as all of these offenses occurred prior to entering this plea. Do you understand that?
Yes, sir.
Now, do you also understand that because this sentence will also include provisions of probation, that you will have to comply with all of those terms of probation, which also would include not possessing a firearm?
Yes, sir.
You also understand that possession of a firearm, aside from a probation violation, also would act as a new offense as you are a convicted felon?
Yes, sir.
Now, do you also understand that there can be let me get there. Do you understand that you're waiving any and all offenses, including any mental health defenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights here. At the end, I'm going to ask if you understand you're waiving all of those rights, okay?
All right.
Do you understand that by entering this plea, you're waiving the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you?
Yo, low-key, I forgot Stacy Sibby already had a person here. My bad, Stacy Sibby. I ain't even show you no love. Here you go.
I'll say what I like to tender. Stacy did with 30 and into.
Court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Now, has anyone forced you, threatened you, or promised you anything to get you into entering into this guilty plea?
No, sir.
Now, your attorney has worked out certain cases in which, and certain counts in which you're entering a plea of no contest, as well.
That would be
Alfred
the
v.
right
North
front,
Carolina.
the right left, excuse me, the right left side. Front.
Okay.
Yes, sir.
So I'm going to go over each of these indictments specifically as to the counts. Do you understand Alfred v. North Carolina is a situation in which you're not admitting that you are in fact guilty? However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter into that plea. Do you understand that?
I understand.
All right, so we're going to begin with case number 23 SC 188183.
Got them boys in them Fulton County Blues.
You understand you entering a plea of no contest as to the participation in criminal street gang counts, which is 1 and 2.
Yes, sir.
You understand that you'd also be entering a plea under Alfred v. North Carolina in counts 3 through 8, which is the possession of methamphetamine with intent to distribute and the possession of prohibited items.
Go and sub up to sustain overruled. Late night kicky spot.
Yes, sir.
Now, do you understand as to case number 22 SC 181814, your attorney has requested, and the state is not objecting, to an Alfred plea as to the count 2, possession of a firearm during commission of a felony, and count 3, possession of a firearm by a convicted felon.
Yes, sir.
And then that your plea would be a plea of guilty as to counts 1, 2, 3, and 4 on the 22 SC 185532, that being serious injury by vehicle, entering auto with intent to commit theft. I apologize, you know me, I'm a northerner. By taking failure to maintain insurance.
Yes, sir.
Now, Mr. Sharp, understanding that you negotiated these with other attorneys and sort of standing in place, could I fairly accurately summarize the counts for which are the no contest as well as the offer?
Yes, sir.
All right, understanding all of that, how do you wish to enter your plea?
Guilty.
All right, and could that be guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony, theft by taking and failure to maintain insurance, is that guilty?
Yes.
As to the 22 SC 181814, which is the possession of a controlled substance, the possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon, as to counts 2 and 3. Is that under Alfred v. North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, the participation in criminal street gang, what is your verdict? Or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute. And then the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the Alpha.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you would have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call a habeas corpus, and that's if you wanted to challenge the constitutionality of this plea.
Yes, sir.
And do you understand that there is one misdemeanor on here, which is the failure to maintain insurance? Do you understand that you would have up to 12 months from today's date to also file the habeas?
Yes, sir.
Your Honor, I'm going to go ahead over what the factual basis is at this time for each plea, if it pleases the court.
Shout out to FFS. Say he about to board a flight. Y'all wish him safe journeys. Appreciate you stopping by, showing some love. Shout out to FFS.
Judge, I will begin with the serious injury by vehicle case, which is the 22 SC 185532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 at Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. Judge.
The World End said, hit the like button, it's free. Come on, family.
As to case number 22 SC 181814. Had the case proceeded to trial, the state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and positively positively alerted as to contraband inside of the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle. Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. Judge, that was a shared cell, and located inside of that cell included a cell phone, the pills that tested positive for methamphetamine. Judge, the quantity would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending upon what day it is at Rice Street. And Judge, possession of Apple AirPods and an iPhone as well. Judge, I'll begin with what the...
Trying to lock them up for AirPods and the cell phone.
Negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation.
Shout out to Steph JK. Y'all go sub up and check her music out. Fire music. Coldest mod in town.
Probation. And count 2 would be 5 years probation to run consecutive for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10. The count 2 is going to be 10 to serve 3 commuted to time served, balance on probation, yes, as opposed to 10 years probation.
I will defer to you as you were the one actively involved in negotiations on this one, Mr. Sharp.
Okay, so if you just go over those again for the record, for count, for 22 SC 181814. Count 1
is possession of controlled substance. That would be 3 years commuted to time served. Count 2 would be 10 to do 3 commuted to.
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm, at some period of time, to statute minimum of 1.
Okay.
So if we're going to do that,
I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3 commuted to time served, balance probated, and count 2 would be 5 years probation consecutive.
Correct.
The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
All right, so let's be clear. Count 3, 10 to serve 3 commuted to time served, balance on probation. Count 2, 5 years probation consecutive to count 3.
Yes, sir.
Yes, sir.
And count 1, 3 years to serve commuted to time served.
Correct, sir.
Yes, sir.
You may continue.
And as to case number 23 SC 188-183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, if the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation. There would be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There is to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang. And there is to be no possession of a firearm on his person in any vehicle in which he occupies nor any residence. Quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Sharp had approached me about concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is the only case that was assigned to my unit, and I believe it actually was initially with the high-profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present. Specifically because he is already a C recidivist, this is irrelevant, frankly, whether or not we would be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of the larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation, had this proceeded to trial, that this was in fact a shared cell. Judge, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, as well as the fact that there was a shared cell, so there was other individuals that would have had access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done.
You said love Cha new emoji. What's up? Einhorn, you don't like your new emoji? You want me to change it blue? What's going on? You got a horn in there too. Appreciate you, family. Y'all make sure y'all hit that like button. They say we about 30 likes short. Hit the like, subscribe, tap in, share with a friend.
In this case, and I've been provided with that would have demonstrated possession or control or intent over the narcotics or objects inside of that cell, we probably would be in a different situation. But I am not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that if we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I wanted to be able to distinguish Mr. Jackson from other defendants that maybe argued were similarly situated.
All right, thank you. So will you go over the special conditions again so I can make sure I have them correct?
Yes, Your Honor. The special conditions would include banishment from the Metro Atlanta area with exceptions for the Atlanta airport. Judge, that would also include that he is to maintain gainful employment while on probation. There is to be no contact or communication, directly or indirectly, with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication, either directly or indirectly, with any persons associated with a criminal street gang, as well as a no possession.
That's crazy. Not guilty and still got to go through this type of shit. What up, Shay? I see you. Appreciate you joining.
Of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge. So there's going to be a sort of a grace period, at least from the state, in relation to him being in Fulton County until he's able to go ahead and work that particulars out with probation for the interstate compact.
Because another jurisdiction has to accept him as a probationer, correct?
That's correct.
All right. Anything else?
Nothing from the state at this time, Your Honor.
All right. Anything from defense?
Your Honor, I would just like you to know that Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court, supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity, and I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is, and we only get one. And I think he wants to make everyone proud, all the supporters proud, and the people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is, Your Honor.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one. I understand that there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
Your Honor, I anticipate that at some point in the future there will be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that that would probably be the best workaround at this time, and quite frankly, in the future, if things are going well on probation, then maybe we can revisit some of these conditions.
All right. Yes, but you have to tell us who you are for the record.
I'm Ms. Jones, Officer Jones with Probation DCS. Due to the fact that where he's going, if they do not accept his case, we will have to come back in front of the judge to modify the seat. I don't know that right now, and I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get the situation expedited, but he won't go to the probation until Thursday.
All right, thank you. So essentially what she's saying is until the state that you are moving to accepts your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area. Okay? All right, as to indictment 23 SC 188183.
Guess he going to Texas, y'all.
Indictment 22 SC 181814. Indictment 22 SC 185532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alfred plea or just a regular guilty plea. All right? So we're going to start with 22 SC 185532. The negotiated and recommended sentence is on count 1. The defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served.
The World's End, you saying you live right now? Drop the link in the chat. You got a thing. I didn't know you go live. Y'all go show some love to the World's End.
Indictment 23 SC 188183. On all 8 counts, 5 years to serve, 2 commuted to time served, balance on probation, to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572.
Yes, this is the other charges from the other, from a different, separate from the YSL trial.
Don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So the people who used to be your friends or the ones they say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with, because if you have contact.
What up, Andrea? It was playing when the first time I said it. I don't know if you heard me. Shout out to Andrea. Appreciate you joining the family.
With them, you run the risk of being violated on your probation, and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail, and unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it, because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process, and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems. Because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem, and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail. as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years. And nobody's going to say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they've signed off on it. You are not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any street gang, criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572, so you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there, so there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing. If we could put on the sentencing sheet that all these sentences are to run concurrent with the sentence that Mr. Jackson has from 22 SC 183572. Any
objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want me to tell you or the court what I'm going to tell Mr. Jackson, I can talk to him.
Yes, just put it all on the record about reporting.
Okay, so he will report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303 at 8 a.m.
So, don't be late. Don't miss that appointment because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right. So, at this time, is there anything else from either party?
Judge, just Mr. Chardon recommended. I have no intention of leaving my office anytime soon, at least voluntarily. So Mr. Chardon and I have built up a point of trust and communication over the years. I have no problem with Mr. Chardon reaching out to me if there's any exceptions that are necessary.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you, Your Honor.
All right. If there's nothing further, then all parties are excused.
Thank you, Your Honor.
Welcome.
Shout out to SB going home. His new home, Texas, with Kayla. Kayla B. SB and KB.
Yes.
Look at watching, watching.
Position 7 on the final plea calendar.
Hold on.
Excuse me. Position 1 on the final plea calendar.
All right. Position number 1, indictment 23 SC 186907. Marquisha Knox.
The last opportunity. Yeah. No, go ahead. Go ahead. Okay. This will be the final.
Shout out to that. All right, this is gonna be the last one, family, and then we're gonna see y'all at 7. But we're gonna rock out through this one. It ain't that long. It's like 10 minutes. Appreciate y'all being here, family. Make sure you hit the like, hit the subscribe, tap in, share with a friend.
Opportunity today to enter a negotiated guilty plea, and that would be a plea that
4K gold.
Both sides have agreed to a recommendation, and
y'all hit the subscribe, show us some love on the subs. We trying to hit 4K. Shout out to Chot Diggy.
If the court accepts the plea but sentences to something outside of that recommendation, Mr. McMullen would have a right to withdraw his guilty plea. After today, any plea that is tendered would be non-negotiated, meaning that if he decided to enter a guilty plea, any sentence that was statutorily authorized would be a possible sentence, and there wouldn't be any right to withdraw the plea simply because of dissatisfaction with the sentence. I just wanted to make sure, and I know, Mr. Dark, you've told that to Mr. McMullen already, but wanted to make sure that's on the record. All right, and I'll ask Mr. Abadi to please let me know what the state's offer was.
Yes, Your Honor. On the 8th of December this year, the state sent an email to counsel for the defendant where the state agreed, or the state's offer was the defendant plea.
Am I tripping, family? Did we play it? Oh, no, this is the last one.
Count 1, conspiracy to commit RICO, and then count 2, but the lesser included offense of murder, voluntary manslaughter, with a sentence of 20 years to serve, all of that time being parolable or parole eligible. It's my understanding that at this time the defendant is not accepting that plea offer.
Different prosecutors, different defendants, different defense attorneys. So it's a chance that you are taking, and you obviously have the right to proceed to trial. You also have the right to enter a non-negotiated guilty plea, although you could only enter a non-negotiated guilty plea to the charges that are in the indictment. I, as the judge, don't have any authority to reduce charges. So what I mean by that is, unless the state agreed to permit you to plead to voluntary manslaughter instead of murder, the only pleas I could accept would be to the murder and the conspiracy to violate RICO. So it's the prosecution's sort of venue, if you will, ability, and only theirs to lessen the charges. Okay, you understand that also? All right. Okay, Mr. Dark, is there anything you want to put on the record right now?
No, Your Honor. It'll be 7 Pacific Standard Time, so 9 p.m. Eastern Time. Maybe 6:30, 8:30 Eastern Time if I'm able to get home early enough. Appreciate y'all, family.
Okay, and we discussed some timing already in your absence when I had the rest of the attorneys here. And what we all have settled on is the state gave an expected duration of trial of about 3 months. They think that's probably on the outside, but that's what we will anticipate at this point. We are going to have a status conference in this case on January 17th at 10 a.m. And we're going to discuss jury questionnaires and the voir dire process and things like that. And can you let me know, Mr. Dark, I know that some of you started the trial that already occurred, started voir dire, and some of you didn't, and I don't know what Mr. McMullen did. Was he a part of the past trial when it started?
Shout out to the world's end. Appreciate you, family.
The mother told me that he's in custody for the past 2 years with no counsel, so I don't believe that he would participate.
Okay, all right. And when did you become involved in the case, Mr. Dark?
I just was appointed, I cannot remember right offhand, but I know it was within the last 60 days, I think, Your Honor, 60 days or more.
Your entry was August.
August, yeah.
Now, that's a lot more than 60 days. That's more like 5 months.
It was August in the other case, and then in this case, it was in July 19th.
Okay, 5 months.
Some other case or something.
Yes.
But Your Honor, as I was saying at the last,
What's up, Keisha E? What's the problem? Let me know. Who messing with Keisha E? I got you.
court appearance.
Mm-hmm.
I just got the discovery on this case on, I think, the 11th. And then I don't know whether these other matters.
And as I said to you at the last conference, you should have been able to get all of the discovery from the, you said there was no prior attorney? Okay, well, it was your responsibility when you were appointed to the case in July to reach out to the state and say, hi, I'm in the case now, I need the discovery. So I'm not going to delay the case past the trial that we're going to have of all of the remaining co-defendants. So you're just going to have to spend your holidays getting up to speed.
To be clear, I'm not asking for a delay. I'm just putting on the record the conditions under which I'm working, and I want to be effective.
I don't see nothing scheduled for Survivor Speaks yet, but y'all go sub up. She might be going live today.
For my client, I don't think that he should just be forced into trial just because, for whatever reason, an attorney was finally found for him after 2 years.
Okay, well, there was no trial for him within the last 2 years. If you were appointed in July, you've already had 5 months, and you'll have at least 2 more months to get ready. 7 months to get ready for a 2-count case is plenty of time. So use your time wisely. Mr. Abadi, did you already provide Mr. Dark with the discovery? I know we discussed that on December 3rd.
Yes, Your Honor. I believe it's everything, but I'm not. I want to make sure I'm 100%.
Okay.
What about Central? I don't know. I had to check.
Yes.
All right. So the other dates. Lost my place now. Lost my place. Okay. So we are planning to at least start from the jury questionnaires that were used in this prior version of this trial, which should be filed, and any additions or deletions that...
Dang, you know what? You right, Chloe. I forgot. I'm talking like I'm in Cali. I forgot I'm not even in Pacific Standard Time. I forgot I'm in a different time zone.
You would like have to the court and opposing counsel by close of business on June.
I don't have no daylight savings where I'm at, so that's what's mixing everything up, because I don't have no daylight savings, so it switches things. I might need to adjust to get on y'all's schedule.
January 16th, and any and all motions in limine are due by close of business on January 15th. The state is going to take a critical look at the discovery and potentially narrow what is going to be used at the trial. So you should have everything now, but everything may become a smaller subset of what you have now. And so they will get that to all of the defense attorneys by February 3rd so that you know what you don't have to worry about in terms of discovery. And we are looking at February 24th to begin the trial. And sometime between January 17th and February 24th, we may, before that date, get the jurors into, we're envisioning them coming in to answer the jury questionnaires on tablets and so that we've got an electronic version of their answers, and they're here. I mean, they may be here, they may be up in jury in the, I don't know if they'll be in the courtroom or not, but somewhere in the courthouse to answer the questionnaires, then get those to everybody, and then have them back to do actual jury questioning and jury selection. So we'll talk about the ins and outs of all of that on our January 17th conference. All right. So do you have any questions for me, either of y'all, with regard to how the case is going to progress? All right. Okay. Then how about you, Mr. McMullen, do you have any questions for the court?
Shout out to Chad Diggy's son. Y'all send him some best wishes. Show him some love. Drop him some slime, brothers. Drop him some slime in the chat. Show him some love. Some welcome homes.
All right. Are you going to want a few minutes to talk with your client after this, or did you have enough time beforehand?
I wanted to follow up because he had a question when we started.
All right. Okay. All right. We're going to go ahead and finish this, and then I'll give y'all some time to talk in the back. I want to talk with you before you go back there, though, Mr. Dark, about the appropriate way to handle attorney conflicts. All right. So this hearing is out of close. Thank you.
Lav said, "Where are you? I want to know." Chloe Albert's Revenge answered that, said, "Still on Earth." That's where I'm at, somewhere on Earth. I don't know the time zone. I don't really pay attention to too much of that. That's why it'd be so confusing. Appreciate y'all being here, though. We're going to wrap it up for tonight. Shout out to everybody in the chat. Chloe Albert's Revenge, Andrea, I see y'all, family. Laugh, always have fun. Chad Diggy, appreciate y'all, family. Let's see, Becky Einhorn, appreciate you, family. Keisha E, what up, what up? Appreciate y'all, family. Just Lee, appreciate you. All right. Appreciate y'all, fam. If y'all want some shout outs before we get up out of here, drop your name or say something in the chat, and we'll hit it up before we hit the outro. Appreciate y'all being here. Make sure y'all hit the like and subscribe and tap in and all that good stuff. Appreciate the love, family.
No. Why didn't you, as an officer of this court, tell me? And that's not what the point is. The point is, you as an advocate, is you should have told me. I got a problem with you now. I got a problem with you now. I would suggest you don't say any more. Now you want to have it both ways. You can't. Both sides have an equal responsibility under the rules of professional responsibility. All right, have a seat, sir. Thank you.
How fast things have changed. How fast things have changed. How fast things have changed.
Now I see you running, coming for my come up. Broke out all your shackles, turned it to some armor. Used to be the judge, but now you have no honor. To die with your pride is to...
Song by Reggie Righteous. Y'all go sub up to Reggie Righteous and show him some love.
Live with all your karma. Now you understand. Now you understand.
Another night of fun. There's a lot of fun talking about. All right. Anybody else have any other issues as to...
Uh-oh. Fulton County has no problem coming in here and cuffing all of us, okay? Don't be an idiot.
Are you trying to tell me about myself? You homeless, and you don't even have a mirror to look at yourself.
Here. So I know you all about your principles. But can we please listen to Earl so we can get out of here? It's 4 cops on the other side of that door. You know if they come in here, they're gonna get your ass on a whole lot of other shit.
You lying ass bitch.
I knew it. I'ma hate you, Will.
Don't you never come back to my house, no.
And I hope they blow your motherfucking ass to smithereens.
You better hope they do, bitch. You better hope they do.
This nigga kidnapped me.
I think I'm entitled. You want answers? I want the truth. You can't handle the truth.
What are you, fucking nuts?
You thought.
All right, family. See y'all at 9 Eastern time. 8:30 if I'm able to make it early on time, because I just got to make a stop, but I got to go by the 420 shop. But if I'm able to make it here then, but if not, for sure at 9 p.m. Eastern time. Appreciate y'all, family. We out. Yes, this is a comfort break.